Hello, everyone. This is a reflection for the finals regarding a case uh, in the subject laws, uh, GR number 247348, November 16, 2021. So the title is Kadahas versus People of the Philippines, Cybercrime and Child Pornography in Digital Age. So let me share my screen. So as you can see, this one it's long, so I'll just use this as background. So based on the questions, what is the case all about? What are the facts of the case? What are the issues, the ruling, and my key takeaways for the said case? So let's go with the facts first. Number one is that uh, Christian Cadahas, he is a 24-year-old canteen worker, uh, which he formed a relationship with a 14-year-old, a minor, named AAA, after mutual interests were exposed via Facebook Messenger. Uh, Despite AAA's mother, which is the daughter, the 14-year-old, BBB, which is the father, warning Kadahas to stay away from her minor daughter. The relationship continued. BBB discovered their ongoing communication, including a conversation wherein Kadahas coaxed a AAA or AAA into sending him explicit photos, which are the breast and vagina, which are nudes. Uh, Upon confronting her daughter, BBB was able to access Kadahas' uh, Facebook Messenger through AAA's course cooperation and discovered explicit messaging between the two. Uh, what happened is Kada has gave the permission, uh, the password or the uh, his password for his account, which he appealed, uh, which he appealed that his rights is being violated. Uh, his privacy was being violated, but it's not because he provided the password. So you can see, uh, the father was able to access the messenger and able to see the explicit messaging between them. So Kadahas was later charged with violating Anti-Child Pornography Act of 2009, which is RA number 9775, as facilitated through cyber means. Cybercrime Prevention Act of 2012. These cases filed against him moved through the legal system, culminating in a trial at the Regional Trial Court, RTC, of Valenzuela City, excuse me, where he was acquitted of one charge but found guilty of child pornography. Because the fact is, even if uh, no, 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 sorry, uh, it's a child, it's a minor, it's a 14 years old female. Uh, Providing a nude any parts as if you look at here, let's go back. Uh, Based on the case, sorry, you can look. Where's the case? Uh, so here, uh, Section 3, definition of terms. Child pornography refers to any representation, whether visual, audio, or written combination thereof by electronic, mechanical, digital, optical, magnetic, or any other means of child engaged or involved in real or simulated explicit sexual activities. Uh, um, uh, explicit sexual activities includes uh, lascivious, exhibition of genitals, buttocks, breast pump, pubic area, or anus. So, from the foregoing, can be convicted of committing child pornography upon proof of the following: victim is a child. That's number one. That is already checked. Victim was induced or coerced to perform in the creation or production of any form of child pornography, which is based here. The judge and AA's uh, conversation that uh, Kadahas was asking for her, and she keeps pleasing. She kept asking, please, please, please. But by then, AAA sends a photo because she was tired of it. So it's a problem. So let's go back. So he was acquitted of one charge, but he was found guilty of child pornography. So he was charged two, child abuse and then child pornography. Child abuse is dropped, but child pornography is up. So a decision later is upheld in the Court of Appeals with a modified penalty. So what are the procedural postures? Kadas appealed to CA's decision to the Supreme Courts through a petition for review on certiorari. Under Rule 45, he contested that admissibility of evidence against him, the interpretation and application of relevant statutes, and the sufficiency of proof of guilt. So I already answered number two. So the case is all about child pornography. So it's a malicious topic. So what are the issues? Let's go back. So the issues are: what was the evidence obtained from Kada's Facebook account inadmissible on the grounds of violating his right to privacy? Did Kada's action constitute an offense under the cited statutes? Um, was the interpretation of unlawful acts under Section 4C2, uh, this one, sorry, 4C2, 4, here, okay, okay, 4C2, 4C2, child pornography, here you go, sorry, uh, 4C2, which is child pornography, Section 4A, uh, Section 4A and C5 of RA 97 correctly applied to CA. So, C5 of RA number 9775. So, 9775. C5. Okay, let's see. See what is C5. Okay, C5. This is A. But yeah, that's the thing. So now, those were the issues. So now let's go to what is the ruling of the Supreme Court then. So the ruling or the court's decision, the Supreme Court denied the petition, affirming that the CA's decision, but modifying Kadaha's sentence to reclusion perpetua pursuant to the Cybercrime Prevention Act's provision. The SC held, number one, Kadaha's right to privacy was not violated, as the evidence, like I said earlier, he gave his password. It's like you are saying that someone has trespassed your property when you have provided them the keys. Like that's a a clear example. So, Kada's right to privacy is not violated. So, Kada has had forfeited his objection to the evidence by not contesting its admissibility during the trial. Kada's actions fell squarely within the ambit of child pornography as defined by law, facilitated through the internet, a medium covered by the Cybercrime Prevention Act. And the CA had correctly interpreted the statutes considering the clear legislative intent to penalize act of child pornography regardless of the medium. And there was sufficient evidence to convict Kadahas as the exchanges between him, the minor indicated inducement or coercion to perform act falling under the prohibited category of child pornography. So, uh, my key takeaway here is just stop. Just don't engage in child pornography. Don't be a pedophile. Uh, Regardless of time and age, uh, engaging with minors in sexual activity is never a good thing. It's a very wrongdoing. It's not it's not yeah, it's not a good thing to do. It's very bad. So as you can see, the law covered uh, the daughter's AAA's rights because she was a child during that time. So the case happened in 2019, 2021, November 16, 2021. So it's just recent. So if we are now in 2025 and she's 14, oh no, never mind. On the part, petitioner had admitted sending AAA the message, already ako sa ganyan. Sige po ba? He however denied him. On November 17, so on 2016, she was 14. So, 2014, 2025, 2016, 2025. So she's a legal age of now. So just please don't be uh, don't do child pornography. Be a decent human being. That's all I can say. So that's all. Thank you for watching my reflection uh, for this case of Cadahas, Christian Cadahas E. Cabias, petitioner versus people of the Philippines. That's all. Thank you for watching.